Hello, 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 and welcome to another fantastic episode of Anarchy Among Friends Roundtable discussion. Before we get started, let me first remind you that we are covered by the BIPCOT No Government License, which allows for the use and reuse of this podcast by anyone and everyone except for governments and the bludgies thereof. You can learn more about that at bipcot.org. That is BIPCOT.org. We're also protected by Brandenburg v. Ohio, 1969, which ruled that the government cannot punish inflammatory speech unless that speech is, quote, directed to inciting or producing imminent lawless action and is likely to incite or produce such action. Therefore, everything said here on Anarchy Among Friends Roundtable discussion is entirely hypothetical.
Don't drone me, bro.
Yeah, I'm also going to say this episode is entirely for educational purposes only.
Yes,
We are not soliciting legal advice.
Yeah, hashtag not legal advice.
Hashtag not legal advice. All right, well that's going to be the episode name now.
I can't take credit for that. That's actually the guy who does Legal that podcast. He every single time he starts out, he's always like, "This is hashtag not legal advice."
So.
If you take legal advice from us, you are stealing.
If you take legal advice from us, you got other problems.
You, dude.
There's some major Darwinism going on there.
Yeah, you deserve whatever comes your way if you take
some Miss-Darwinism or something.
Yeah, never, ever take legal advice from anyone. None of us are licensed attorneys. None of us can legally provide you with any legal advice. None of us are representing you.
I stayed at a Holiday Inn once, so I mean, I got that.
It's got to be a Holiday Inn Express, or it doesn't count.
I did stay at a Holiday Inn Express last night. Hey, I might play a lawyer on TV. You never know.
That was on Pornhub. That's not a real lawyer.
Well,
well.
I was also once an astronaut, and
yeah. So we're recording this on Friday instead of our normal Sunday because
it's a special episode.
Because fucking shit is stupid and stuff, and I think that's as elegant as I can make it.
Everybody shit's all emotional.
There's no other way to describe it other than everything is just coming completely unhinged.
Yeah, some people are drinking the Brondo, and they're not growing.
But it's got what plants need.
It's got electrolytes. It's what plants crave. That buildup of sodium is not good for the soil, people.
Yeah, there's some serious oxygen thieves. I'll just leave it at that. But
now baiting.
We want to discuss this ruling from the 9th.
The 9th Circus.
Yeah.
The 9th, which
actually
this 9th Circuit panel ruling actually undid a previous 9th Circuit ruling.
I remember that because we talked about that on the show too.
Which is okay.
It seeks to undo an awful lot, actually.
It's scary. It's scary how much negative effect this ruling can have.
Well, and I think that it, if anything, points to the reality that we are under an oligarchy.
Yeah.
The fact that it can alter so much, a single court decision can alter so much, says pretty clearly it's an oligarchy.
It's in like direct opposition of like every other case on the issue.
Yeah, actually, I mean, like basically all of them ever in the history of the United States.
We might get SCOTUS to actually have a ruling on a major gun case, though, for the first time in a decade.
But do we want do we want them to, though? Because the problem is if they go the wrong way, and I don't think they will, based on, historical jurisprudence and similar rulings from SCOTUS.
Well, going back to Heller and stuff.
Yeah, but at the same time, we're still relying on the government, the Supreme Court of the United States, to, essentially, yeah.
Yeah, well, and the fact is that, Jason, you brought up Heller. Wouldn't this fly in the face of Heller too?
Wasn't it Heller
Yeah.
that forced the state of Illinois to draft some sort of concealed carry legislation?
DC.
Yeah.
But I mean,
but it basically forced Illinois' hand too, because they were absolutely not. We don't recognize anybody. We don't anything.
That's what it is here. It's a may issue state.
Yeah, but Illinois even is a shall issue. It's just
I think
ungodly expensive.
I think Illinois like requires a FOID card and
for in-state. They have an out-of-state permit that you can get too, but it's like $300 for the first year.
Why would you get a fucking Illinois permit?
And then on top of the $300 a year, you have 16 hours of required training that you have to go through. That's in the state of Illinois, so you have to transport your weapon that you're not allowed to have in Illinois into Illinois to train with.
Yeah, is that the same state that requires like that you get like 3 letters to a judge and like you need?
I don't think they have that.
I don't remember who that is.
I do know there is
requirements, but
yeah, I don't think that's Illinois. I think Illinois is as long as you take your mandatory 16 hours of training, so a 2-day class, and then on top of it, you have to pay. If you're in state, I think it's 150. Out of state is 300, and you have to file it through the local county sheriff.
Yeah,
and
Illinois. See, Illinois doesn't honor concealed weapon permits from a single other state.
Nope.
But there are 29 states that will honor Illinois.
Yeah. I think Wisconsin is honored in 29, 30
for
states.
5 years. Nice.
Yeah, Wisconsin's permit's the same way. But still, it's like $300 to apply for it. In the state of Wisconsin, if you decide to get your concealed permit, it's a $50 fee, and you need hunter safety.
Yeah, it's okay. So, I guess it was it's New York. So, Liz Joy, blue check mark. But she posted pictures of her incredibly bruised body post domestic violence.
Mm-hmm.
And she said, to get my pistol permit, I had to take a New York safety class, take and pass a handwritten test, pass a target shooting class with a certified instructor, get 4 letters written on my behalf to the judge, write a letter to the judge on why I wanted a permit. And that was all just so that I could prevent, and it's a picture of all of her bruises, this from happening again.
Yeah. And then she only gets 7 rounds on top of that.
Yeah. I mean, this is the kind of undue burden that already exists, even with the ability to bear arms.
Mm-hmm.
And now the Ninth Circuit says, no, I know that's part of the Second Amendment and everything, but nah.
Yeah. All right. So we're beating around the bush. Let's just get into this article. This is we're going to cover the Courthouse News Service article on it because I don't know, I like the way they put things. But it's the ruling was carrying guns in public is not a constitutional right, according to the Ninth Circuit. So the article goes on. It says Americans have no right to carry guns in public. A divided en bloc Ninth Circuit panel ruled Wednesday, reversing a prior Ninth Circuit decision that struck down a Hawaii firearm restrictions as unconstitutional. Quote, there is no right to carry arms openly in public, nor is any such right within scope of the Second Amendment. That is according to U.S. Circuit Judge Jay Bybee, a George W. Bush appointee, who wrote for the majority of an 11-judge panel in a 127-page opinion piece.
Let that sink in for a second. They had to convolute their opinion piece so badly that they had to basically word vomit on 127 pages.
It took them 127 pages to justify saying no, you shouldn't be able to carry guns in public.
Yeah. And bonk or bank, however you want to pronounce it. It's Latin. Who cares?
Yeah.
Means full bench.
Yeah.
That's the full Ninth Circus.
Yeah.
So, article goes on. Looking back on 700 years of legal history dating back to the 14th century England, 7 judges in the majority found, quote, overwhelming evidence that the law has never given people, quote, an unfettered right to carry weapons in public places. Hold on. This is what they're saying. The first quote, the quote says, nor is any such right within the scope of the Second Amendment.
Right?
So the quote that they said, nor is any such right within the scope of the Second Amendment.
The
right Second
to
Amendment,
keep and bear arms.
No, hold on. What I'm getting at is Second Amendment ratified 1791.
And they're going all the way back to the 1300s.
They went back to the 14th century England to find, quote, overwhelming evidence that it, quote, unfettered right to carry weapon.
So in essence, they're going for, hey, we left this country because of this other country because of tyranny, but we're going to use their laws and their rules
as justification
for limiting your ability to carry a weapon in this country 7 centuries later.
They went 700 years of legal history going back to the 14th century England to justify violating something written in 1791 in a different country.
My first question, really,
I think what should be
everyone's what should be everyone's biggest question is, what didn't we fight some sort of thing to not give a shit about English law anymore?
Yeah, I feel like there may have been something late 1700s.
There was something about like this really epic breakup letter, and then they wanted us back, and there was a fight, and they left with their tail between their legs.
And rather than going back to the abusive boyfriend, this thing broke away and actually learned to live by itself.
And then, a few years later, because of the Second Amendment, when the abusive boyfriend came back, we were able to fight him off again. And he really ran with his tail between his legs.
And then there was the abusive boyfriend's friends tried some stuff. And because of the Second Amendment, they got, the shit kicked out of them also.
And I seem to remember that the girlfriend in the situation actually showed up to bail the boyfriend's ass out in the early to mid 1900s.
Twice.
Something. Yeah, twice.
Two times.
All right.
Just something pops into my head about that.
All right. This is where Andrew's going to lose his shit. So hold on. Take a deep breath, Andrew.
Cheers, Andrew. Here we go.
I have quotes prepared. I have resources.
No, you don't have one for this one.
Oh God.
The 7-judge majority traced legal text and laws back to 1348, when the English Parliament enacted the Statute of Northampton, which banned carrying weapons in fairs or markets or before the king's justices. It also cited multiple laws from colonial and pre-Civil War America in which states and colonies restricted the possession of weapons in public places.
Do you know who was restricted in the antebellum United States from carrying weapons? Would you like to know what laws they're citing? Do you want to know?
You could see if you're watching the video. If you're watching the video on YouTube, you saw it. But if you're not watching the video, just listen. Andrew was winding up. You could see his eyes getting bigger and bigger and bigger and bigger.
And you could see his face turning color to match his goddamn beard.
Do you know who was... if you listen to the show, you know who those laws forbid from carrying.
Oh.
Who? Let's see. Chris, do you know who was forbidden in the colonial America and in the antebellum United States from carrying weapons?
Gosh, I feel like there was a discussion about this the other day. It may have something to do with people that were slightly darker complected than we are?
Was it? Gosh, yeah. Hey, turns out that what they're referencing in this opinion in 21st century United States are laws that forbid the carrying of weapons by natives and I quote from the law, Negroes, free and slave. Those are the laws specifically that they are referencing. Those laws. Them.
The very laws that, everybody nowadays, especially the woke tards, are like, oh my God, equal rights, equal rights, equal rights. They're quoting the laws that specifically limited the rights of minority populations.
The laws that are the reason. There's a chapter in For the Defense of Themselves and the State by Clayton E. Kramer called No Negro Shall Be Allowed to Carry Firearms. Those laws. Those are the laws they're talking about.
Yes, the original gun control laws in this country were based on race.
Completely centered around race, and modern gun laws very largely are, but much more slyly.
Well, yeah, because modern gun laws, they disproportionately affect the disaffected. So those that maybe don't have the monetary means to go out of their way to acquire certain pieces of equipment, or those who are convicted of nonviolent offenses, which, drug crimes kind of tend to center around. And I seem to remember us doing an article once upon a time about a disproportionate number of minority inmates are there because of nonviolent drug offenses. God,
you know why there's a $200 tax stamp in the NFA? Because it was believed that people of color would never be able to pay that.
Yeah, that's.
I wonder how Coley and Noir feels about that.
1934, right?
1934. Like yep, the NFA. It's
$200. $200 is a lot of money back then.
$200 is equivalent to roughly $1,200. Well, roughly like $1,200 now.
No, it's more than that.
If you put it in the context of the price of arms at the time, it's a $1,200 roughly.
We have an inflation calculator.
Well, yeah, with inflation, but I'm saying like when you
that's what we're talking about is inflation. With inflation, it's about $3,000, $3,500.
It's an enormous amount of money. It is. It's
cost $200 in 1934 is the equivalent of $3,925 now.
So imagine you wanted to buy an $800.
That's a scar heavy.
Right. Imagine you wanted to buy an $800 SBR right now, and that had adjusted for inflation. The NFA would require you pay the government an additional $4,000 to buy your $800 SBR. And there is a short shotgun in the Cody Firearms Museum right now that was purchased not long after the NFA was passed. That was at the time a $40 shotgun. $40 for that shotgun. You had to pay $200 to buy the $40 shotgun.
200 plus the 40.
Right.
Yeah.
You're just for permission to pay the 400 or the 40 to buy the shotgun, you had to pay $200 ahead of time to get that.
Yeah. So all right.
This was not designed for white people. And this certainly wasn't designed to keep guns out of the hands of gangsters and bad people, because remember, guys like Al Capone had mansions in multiple states. $200 was not going to be cost prohibitive.
He's not going to pay $200
He wasn't paying $200 anyway.
He wasn't going to pay that anyway, but ostensibly when they passed the NFA, it was to keep guns out of the hands of gangsters. And by the way, what everybody forgets, communist revolutionaries. That's actually why the suppressor ban is there, is because they were worried about communist assassins.
Okay, all right, back to this article. Gentlemen, we're only like a third of the way through this article.
So I'm gonna guess this is appropriate.
Yes. Hold on. It gets better. Yeah, I might have to mute you for this one, for this next paragraph. Okay. This is a quote from Bybee again. Bybee is the one that wrote the opinion. Quote, the Second Amendment did not contradict the fundamental principles that government assumes primary responsibility for defending persons who enter our public spaces. The states do not violate the Second Amendment by asserting their long-standing English and American rights to prohibit certain weapons from entering those public spaces as means of providing domestic tranquility and forestalling domestic violence.
Wait a second. Read that first line of that paragraph again. Read just the first line of that paragraph again.
The Second Amendment did not contradict the fundamental principle that government assumes primary responsibility for defending persons who enter our public spaces.
Okay. Anybody ever fucking heard of Warren versus District of fucking Columbia? Anybody?
How many times has SCOTUS ruled that police have no obligation to protect you?
At least 4 that I can think of offhand.
I think it's like 8, and they just recently ruled it in reference to Parkland.
Yeah,
that's et al. So Parents et al. v. Broward County Sheriff's Department.
Right.
If anybody wants to look it up.
So you have Warren versus DC. I believe it's
Gonzalez
v. Castle Rock.
And then Winnebago.
One from Alameda County.
Yep. But actually, Gonzalez, I believe, was Gonzalez v. Winnebago.
No, Gonzalez Castle Rock.
So there's another one that has Winnebago in it. Mm-hmm. That's actually out of the state of Wisconsin.
Yep. But English law.
Yep, English law.
English law.
I absolutely hate English the skycloth, but you know what? We've already covered that the U.S. doesn't give a fuck about English law.
English law. Yeah.
And there's a reason there was a war fought over the oppressiveness of English fucking law.
And what a coincidence, I've come prepared. So,
hit us. What you got?
To quote, again, this is from the For the Defense of Themselves and the State, the Original Intent, Judicial Interpretation of the Right to Keep and Bear Arms by Clayton E. Kramer. It says, one of the most important sources to look to is William Blackstone, the noted 18th century English jurist, right, whose writings on English law formed the basis for legal schooling in the colonies throughout the Revolutionary period and for many years into the 19th century. Blackstone asserted that personal security, liberty, and property were absolute rights, not dependent upon governmental grants, but no other than either that residuum, meaning remainder, of natural liberty, which is not required by the laws of the society to be sacrificed to public convenience, or else those civil privileges which society hath engaged to provide in lieu of the natural liberties so given up by the individuals. It is essentially, he's there, and there's another quote in there. It's page 6 if anyone wants to look at it. But he is talking about the idea that the right to bear arms is a civil right for personal defense. And this is an 18th century English jurist. If they want to go to English law, let's talk about English law for a minute. And it's a statement of an individual right of a subject and for the natural right of resistance and self-preservation is the quote. It's a really long quote and I'm not going to read it, but he talks about the natural right of resistance and self-preservation when the sanctions of society are found insufficient to restrain the violence of oppression. So, like, if you want to talk about English law, we can definitely talk about English law here and why you're still fucking wrong.
Never mind the fact that we don't give a fuck about English law. Well, I mean, in our circle, we don't give a fuck. But at the same time, it's like, seriously, you're going to go all the way back to before the country, the United States of America, was anything.
Like, not just that. We covered that Heller versus DC, right? We brought that up earlier. Heller versus DC was a direct Second Amendment rights a case that affirmed the right of the people to keep and bear arms
as an individual, right?
Because police have no obligation or duty to protect people.
Yeah.
Right.
That, yeah. I mean, and the thing I was going to mention too, Blackstone also used the phrase "right of having and using arms" in a collective revolutionary sense. When the, quote, liberties of Englishmen, end quote, were subject to, quote, tyranny and oppression, and appeals to the courts and parliament were unsuccessful, quote, and lastly, to the right of having and using arms for self-preservation and defense.
Gosh, I mean, it's almost like you could apply some of those principles to today.
Gosh,
I mean, only in Minecraft.
It sounds, and the funny thing is, it kind of sounds like maybe an 18th century English jurist, a law expert in England in the 18th century. So more recently than the 14th century. Or sorry, 15th century.
All right.
Was disagreeing with them. Gosh.
Okay. Writing for the dissent, senior U.S. Circuit Court or Circuit Judge Dermond O'Scanlan, a Ronald Reagan appointee, said the majority failed to properly interpret the U.S. Supreme Court's 2008 decision in District of Columbia versus Heller, which overturned Washington, D.C.'s ban on handguns and the requirement that rifles and shotguns be kept unloaded and disassembled or bound by a trigger lock device.
So I want to point out this wonderful irony that this guy who was appointed to the Ninth Circuit by Ronald Reagan, who is responsible for the ban on open carry in the state of California.
And who signed the Hughes Amendment into law, which closed the machine gun registry.
He also wrote a letter to Congress in 93, early 94, encouraging them to pass the original assault weapons ban.
Yep.
Yeah, this pillar of the conservative movement, their great big hero. I, in fact, know a hyper neocon who I'm unfortunately related to, who has a giant painting of Ronald Reagan in front of a waving American flag in his home office.
I am not drunk enough to hear that.
All right. Quote, the Second Amendment's text, history, and structure, and the Supreme Court's reasoning in Heller all point squarely to the same conclusion. Armed self-defense in public is at the very core of the Second Amendment rights. That's another quote from O'Scanlan. Plaintiff
nice
George,
Irish name.
Yeah. Scannlain. Plaintiff George Young sued Hawaii in 2012 for denying his applications for permit to carry a concealed or openly visible handgun. A Hawaii state law requires a license to carry a gun in public. Under Hawaii county regulation, the police chief may only grant such licenses to those who need a gun for their job or who show, quote, reason to fear injury to their persons or property. No one other than a security guard has ever obtained an open carry license in Hawaii. Lawyers for the county acknowledged during a Ninth Circuit hearing in 2018.
Wouldn't literally everyone potentially have a reason to fear for their person or property, because it's not like the only people who get robbed are people who have security guards?
Or, I don't know, the fact that maybe that police have no obligation or duty to protect people.
Right. Don't forget, there was that serial killer in New York years ago who would stab people to death on the subway.
Uh-huh.
And that guy that finally caught him.
Yeah,
that guy that finally caught him was stabbing the guy, was being stabbed repeatedly by him, and he had to beat the hell out of this guy while two Metro PD officers stood by and watched.
They stood behind the door.
Yep.
And watched.
Until he himself subdued the guy.
The guy who was currently in the act of being stabbed to death by this guy, right?
Yeah, had to be the one to beat the guy into submission, and then the cops showed up and arrested the guy. Yeah. Because they were under and the Supreme Court agreed that they're under no obligation to protect you, only to punish the guy once the crime is over.
Yes, because they're law enforcement.
Exactly.
Yes. Let's see. Under Hawaii County regulation, okay. No security guard has ever obtained an open carry license. No one other than a security guard has ever obtained an open carry license in Hawaii. Lawyers for the county acknowledged during a 2018 Ninth Circuit hearing. In July 2018, a divided 3-judge Ninth Circuit panel ruled that carrying a gun in public is a constitutional right, and that Hawaii cannot deny permits to all non-security guard civilians who wish to exercise the right. On Wednesday, the in-bank panel majority reversed that decision, finding that the Supreme Court's 2008 Heller decision is not inconsistent with state laws that restrict the right to carry arms in public.
Wait.
Hold on. The majority reversed that decision, finding that the Supreme Court's 2008 Heller decision is not inconsistent with the state's laws that restrict the right to carry arms in public.
So the Supreme Court decision that said that you can't say no to an individual's right to carry arms in public isn't inconsistent with a law that won't allow people to carry arms in public.
Hold on. Quote, Heller, that's the case. Heller found that the pre-existing right to keep and bear arms is not a right to, quote, carry any weapon whatsoever in any manner whatsoever and for whatever purpose. That was a quote from Bybee, who wrote for the majority.
Okay, so I got to bring up another quote here, just because not that it argues against this point, but it makes it fun. So this quote, again from the same book, it says, an individual right to armed self-defense implies a right to carry arms appropriate to that purpose. So a pistol, a knife, a sword, perhaps impact weapons. And it's talking about, so to set this up, it's talking about how the idea that the beginning of the pre-comma part of the Second Amendment is referring to the ability to resist a tyrannical government has never really been in doubt. Like, that's always been a thing established throughout jurisprudence since literally the founding of the United States. But he points out, he says the right to arms for the purpose of resisting domestic tyranny, however, might allow the government considerable latitude in restricting the carrying arms and even prohibition of arms not appropriate to revolution. On the other hand, weapons specifically designed for short-range use against unarmed or lesser-armed attackers, as might be appropriate for self-defense, are of no value for overthrowing a government. So the point that he's making here is that if the purpose of the Second Amendment is solely to resist a tyrannical government, if you're undoing the idea of self-defense as well, and it's solely to resist a tyrannical government, then that's one thing. And if it's solely for self-defense, that's another. But you gotta pick. It's either one or the other. So if this court is saying that it's not for self-defense,
they're saying it's for resistance,
then it's to resist tyranny. And if it's to resist tyranny, then the Second Amendment protects any and all weaponry necessary to do so.
Yes. Okay. So Young is the guy that this case is pertaining to. Young had argued that Hawaii's 169-year-old law impermissibly limited open carry permits to security guards as applied in regulations adopted by the county in Hawaii in 1997. So using a 169-year-old Hawaiian law is what they used to justify the ban on open carrying in Hawaii.
Wait, but so that's before Hawaii, it was a state.
Hawaii became a state in August 1959.
What does that have to do with anything now?
I was going to say, was it even technically a territory of the U.S. 170 years ago?
Are all of these judges Joe Biden that they don't understand what year it is? How? What? So we're going to the 15th century English law. We're going to early 19th century pre-statehood Hawaiian law, and we're using that to determine what the United States Constitution says.
For the record, the United States annexed Hawaii as a territory in 1900.
So it even predates it being part of the U.S. at all.
Yes.
So then this law is from
still in charge.
So then this law is from like the time of the Civil War.
This law actually dates to when Hawaii was a monarchy.
Yes.
Yes.
Interestingly enough, you know when English laws date from?
When England was,
when England was a monarchy. God, it's almost like these guys don't really like the idea of republics or democracies.
Yes.
Like they really want just laws given out ex nihilo from as just a fiat declaration from monarchs to be the ones that they go
What's
by.
the difference between that and an executive order?
Nothing.
All right. During oral arguments last September, a lawyer representing the Aloha State said that the law does not limit open carry license to security guards. He cited the Hawaii Attorney General's 2018 guidance stating that an applicant can obtain an open carry permit by demonstrating, quote, a need to carry a firearm for protection that sustainably exceeds the need possessed by ordinary law-abiding citizens. Hold on.
What?
I'll read that again.
Those were words.
Attorney General.
That's about right, too.
If those words were plain, they're crashing. All right. Hawaii Attorney General's 2018 guidance stating that an applicant can obtain an open carry permit by demonstrating, quote, a need to carry a firearm for protection that substantially exceeds the needs possessed by ordinary law-abiding citizens.
So their ruling seeks to create a special class of citizen.
Essentially.
Yep. Their guidance says, unless you are in active fear for your life, you cannot possibly obtain a permit to lawfully carry a weapon.
I feel like there was another amendment to the Constitution that basically said there wasn't special classes of citizens, like maybe number 16.
Yeah.
13, something like that. I don't remember.
Yeah. The state says the Attorney General's 2018 guidance overrides the county's. So hold on. The Attorney General's 2018 guidance overrides the county's 1997 regulation that ostensibly limits open carrying licenses to security guards.
Wait.
The Attorney General's 2018 guidance overrides the county's 1997 regulation that ostensibly limits open carrying license to security guards.
So this literally says that a suggestion by
a memo. Let's call it what it is. It's a memo.
A memo from an attorney general.
Right. From an appointee, an unelected official, supersedes the legislation of elected officials.
Yes.
The terrorists hate us for our freedom.
Yes.
I mean, are you? I white girl can't even. All right, this is like give me a mocha frappuccino and some UGG boots, man. Like what?
Yeah.
What? What planet does this court exist on? Because it's not fucking Earth, and it's certainly not in the United States.
Despite that argument, O'Scanlan found the fact that the 1997 regulation remains on the books and that Hawaii has never granted permits to a non-security guard civilian shows that the state has been unconstitutionally restricting the Second Amendment rights.
Well, duh.
Oh, yeah.
I mean, it doesn't take a goddamn rocket scientist to figure that shit out.
Well, I mean, and their argument a lot of their argument seems to be that the Second Amendment doesn't apply to individuals. Essentially, like that, it doesn't apply to individual right to self-defense.
No, it doesn't. It doesn't apply to normal civilians.
The average. Well, it doesn't apply to civilians. As I'm saying, it doesn't apply to just.
You have to be part of the upper caste of the civilian order,
right? So
for it to apply to you,
and it's interesting because the Constitution of Connecticut in 1818, Indiana in 1816, Kentucky in 1792, and then re-ratified in 1799, Michigan from 1835, Mississippi from 1817, Missouri from 1820, Ohio from 1802, Pennsylvania 1776 and 1790, the Republic of Texas in 1838, the State of Texas 1845, Vermont 1777, 1786, and 1793 all use the phrase bear arms with the variant of the phrase in defense of themselves and the state, and at no time is that indicated to be exclusively military or security in nature.
All those rulings are long before Hawaii became a state too.
And all of those state constitutions exist way before Hawaii becomes a state, way before this was even declared in many cases. The United States Constitution exists before this was declared, and yet, instead of going back to all of that existing stuff within the United States, they go to what was a foreign country's law.
1348 law from a foreign country.
Well, not even
that
just
we
that,
fought
but
a
the
war
law.
To leave.
Yeah, not even just that, but the Hawaiian law was while Hawaii was also a foreign country.
So this is for the Ninth Circuit Court, which is the Western United States, that were never under English law at all.
Right.
They're not part of the colonies.
Oh my God.
This article is so. This is just. It's. Okay. Quote, in the county of Hawaii, the historical depth or the historical dearth of open carry permits for private citizens is no mere pattern or practice, O'Scallahan wrote. Quote, it is a matter of official policy. Essentially, that's what it is, official policy, 1997. All right, in a concurring dissent, U.S. Circuit Judge Ryan Nelson, finally a normal name. Concerning dissent, U.S. Circuit Judge Ryan Nelson, a Donald Trump appointee, argued that the panel should have remanded the case back to the district court to determine if Young could plausibly allege Hawaii's law had been applied in an unconstitutional manner. The failure to do so could have widespread consequences for the people suing to protect their constitutional rights, he said, especially for litigants representing themselves without an attorney. Young originally filed his lawsuit pro se, but was represented by a lawyer at his appeal. Quote, it will preclude a host of future as-applied constitutional challenges under the First, Fourth, Fifth, and Eighth Amendments previously recognized by the court, especially for pro se civil rights plaintiffs. By upholding state laws that restrict carrying guns in public, the Ninth Circuit joined three other circuit courts that have issued similar rulings, the Second, Third, and Fourth Circuits. Meanwhile, the D.C. Circuit and the Seventh Circuit have struck down state laws that ban open carrying guns in public, makes for a dispute ripe for Supreme Court review. Although some circuit points have...
Now, at this point, you have multiple rulings, even from within the Ninth Circuit, that disagree with their ruling right there.
This ruling overruled a previous 2018 Ninth Circuit Court ruling.
The difference is this is an en banc ruling versus a 3-judge panel. But still, I mean, this is still the Ninth Circuit basically saying, well, what we decided before, let's just forget about that.
Yeah.
Because it doesn't matter. And not only that, but now you're looking at, like you just said, you have other district courts of appeals or circuit courts of appeals that have all said open carry is protected by the Second Amendment by throwing out laws which ban it.
Yeah.
So this is something that it's going to have to go to the Supreme Court. If the Supreme Court throws this back down to the lower court, essentially this becomes the established jurisprudence going forward.
Yeah. Although some circuit courts have upheld restrictions on carrying guns in public, Young's attorney, Alan Beck of San Diego, argued that no court has gone so far as the Ninth Circuit did in the en banc opinion Wednesday. Quote, the Ninth Circuit's opinion, which find that the Second Amendment does not apply outside the home at all, contradicts the decision of every federal circuit court in the country or in the country that has ruled on this issue. We will be seeking Supreme Court review in order to overturn the Ninth's erroneous decision. So
there's and I've been looking through a number of court cases, and
yeah,
dude, do you know how many circuit court decisions disagree?
Yeah,
with this, you have Watson v. Stone, Moore v. Gallup, State v. Plassard, People v. List, State v. Nickerson, People v. Zerillo, a reply to Ramirez, People v. Nakamura, People v. Brown, People v. Ferguson. I mean, and they all disagree.
Yeah. Okay. Bill Clinton appointees William Fletcher, M. Margaret McCowan, Kim McLean, Waldrol, and Chief Ninth Circuit Judge Sidney Thomas joined Bybee in the majority. Circuit Court Judges Richard Clifton, a George Bush appointee, and Michelle T. Freeland, a Barack Obama appointee, also sided with the majority.
Gee, what a shocker.
Yes, Circuit Court Judges Sandra Ikuda and Consuelo Callahan, both George W. Bush appointees, joined O'Scanlan and Nelson in the dissent.
Oh, you know what's interesting that I've just learned? So Moore v. Gallup, which is 1943, basically Leroy Moore Sr. appealed the decision of country judge Earl Gallup, who had turned Moore down for a renewal of a pistol permit in Albany County, New York. What's interesting is that part of the decision said, accordingly, authoritative federal decisions constraining the Second Amendment may properly be applied to the state statute in the interest of hegemony of interpretation. Well, Heller is Supreme Court.
Scutis, yeah.
So under that decision, you can't disagree with it.
Right, because it comes from the court above them.
Yeah. All right, I got one more quote I want to read from you. This is again from Judge O'Scanlan. I've pronounced that name like 6 different ways now. But this is from the Reason article. Let's see. From the judge which wrote for the dissent. Quote, the Second Amendment of the United States guarantees the right of the people to keep and bear arms. Today, a majority of our court has decided that the Second Amendment does not mean what it says. Instead, the majority holds that while the Second Amendment may guarantee the right to keep a firearm for self-defense within one's home, it provides no right whatsoever to bear, i.e. to carry, the same firearm for self-defense in any other place. We now become the first and only court of appeals to hold that public carry falls entirely outside the scope of the amendment's protections. Callahan goes on to say that it reduces the right to bear arms to a mere ink blot.
Yeah, I mean, and you got to remember that the phrase bear is an important part of the Second Amendment. And you know, really, if you go back to look at what that would have meant, right, to the framers of the Constitution in the late 18th century, Noah Webster's first edition of an American Dictionary of the English Language, which was published in 1828, is probably a really good place to go, because Webster not only, you know, is it an American dictionary specifically, But Webster happened to be one of the guys who helped with the debate on the Constitution. So he's probably in a position to know what the hell they meant. And according to him, bear is to wear. To bear is a mark of authority or distinction, as to bear a sword, a badge, a name, to bear arms and a coat. There's nothing specific to military service, or by extension, obviously professional security service in this case, in that definition. In fact, even the Oxford English Dictionary doesn't truly have a solely military sense of that word, to bear. So, I mean, and that use, the idea that, you know, to bear arms refers to just weapons in general and not in military service. If they want to go back to the 1400s, I'll do you one better. I'll go back to the 9th century and the saga of Beowulf, which indicates that to bear arms means to carry them on your person.
Yeah. Yep. Here's another quote from Bybee. Bybee wrote for the majority. Quote, the government may regulate and even prohibit in public places, including government buildings, churches, schools, and markets, the open carrying of small arms capable of being concealed, whether they are carried, concealed, or openly. Quote, we need to go further than this because Hawaii's firearms licensing scheme young challenges only applies to a pistol or revolver and the ammunition therefore. See, this is the wording that scares me. This is the wording that scares me. Open carrying of arms capable of being concealed, whether they carry concealed or openly.
Yeah, because effectively it bans open carry as well.
Well, that's the
whole point of the ruling.
That's the whole crux of the case is open carrying.
Open carry, but essentially, if that gets applied, that even bans states where open carry is a constitutional carry, like Wisconsin, for instance, where it's considered a constitutional right. Mm-hmm. And it means that if they can convince somebody that a weapon is concealable, carrying it on your person is automatically a violation.
O'Scallahan also said, a total ban on carrying a handgun outside the home does not implicate that the Second Amendment or a total ban on carrying a handgun outside the home does not implicate the Second Amendment right to bear arms whatsoever.
What?
So you're good.
DC versus Heller might have something to say about that.
Well, and not only that, but I mean, again, it's the point I made earlier. Would you have to pick one or the other? Either
right.
Weaponry is the point of the Second Amendment is to preserve weaponry that you can use to resist tyranny, which would be military grade, right? Resistance grade weaponry. Mm-hmm. And it also includes possibly the right to self-defense. But if it doesn't include the right to self-defense weapons, it must necessarily protect all resistance grade weaponry.
God, I love that term.
You don't get to pick like, oh, neither, because that's to disregard the Second Amendment entirely. It's one or the other. Like you know, you can't. Either it includes both or it only includes one, but the one that has never, ever, ever in the history of the Second Amendment been in debate is whether or not it allows you to hold weapons that allow you to resist a tyrannical government.
See, and we can even go further than this. You know, it says bear arms, right? It doesn't say guns. It says bear arms, right? Well, arms are more than just firearms. Right, we're talking knives, yep. Right? Canes, whatever. Anything can be used as an arm,
as a means of self-defense. Brass knuckles,
right? So,
tasers.
So how far is this going to apply? Mm-hmm. Right? I mean, is it going to ban the carrying of knives openly? Okay, well, you can't carry them concealedly. Well, okay, now you can't carry a knife at all. What about a multi-tool? What about a cane? A walking stick?
And does it go so far as to, okay, you can carry a cane, but there are a lot of states that allow you to have like cane swords. So if that cane is also a sword, then are you technically carrying a concealed weapon? And
you know what's
little Timmy carried a baseball bat to practice. Is that open carrying an arm?
Well, yeah, and you know what's interesting is that, I mean, historically in the United States, the way that laws that are intended to restrict weapons are phrased is they list things.
Yeah.
So they will list, like there's multiple laws and court cases, especially from the mid to late 19th century, that talk about Bowie knives, and if anybody's unfamiliar with just how big a Bowie knife is, let me explain to you. They are not small.
15 inches or something like that, right? Isn't that what Jim carried?
Yeah, this one particular one that I'm holding, if you're listening, you can't see it, is 14 and a half inches. I love this knife too. I've used the hell of it. But it'll list like brass knuckles, Bowie knives, swords, and it lists like pistols separately. Like it has to like say all of these things, because their fear was that people would use the phrase arms to only mean firearms and not apply to anything else. Well, this could not only mean firearms, it could mean everything else, or it could not, depending on how you want to look at it. And the way that historically our court system has worked, that's a fucking crapshoot. Who knows?
That one, yeah.
I mean, even the right to keep and bear arms for the means of self-defense, to conceal carry or to even open carry, historically in the court system is a fucking crapshoot. It's back and forth and back and forth and back and forth and back and forth, depending on where you are and what the time frame is and who was doing what. And a lot of laws are intentionally written essentially so that the court can decide whether or not they like someone. And if they like that person, then they can let them off. I mean, it's... I'm not even like, seriously, like there's got to be 30 different laws in different states that are so vaguely written. Like they even include words, and they're still on the books, by the way. They even include words like people of good moral character. So it's just, I mean, this kind of highlights how absurd the idea of not going Second Amendment full stop is. Because the moment that you go, well, maybe it only protects these guns, maybe it only protects this, maybe it only as soon as you do that, things get so arbitrary so quickly that it will never make sense. It's got to be an all or nothing to make any amount of logical sense.
And you could even take an argument like this with the Second Amendment and apply it to things like the First Amendment. You always hear the argument from those who want to ban modern weapons that the Second Amendment only applied to muskets. Well, okay, well then your First Amendment to tell me that it only applied to muskets only applies if you put it in a newspaper or write it in calligraphy with a quill pen.
Well, you could print it with a printing press too, to be fair.
Well, yeah,
those totally existed, but
that's why I said,
the fourth doesn't apply to your cell phone or your which it doesn't because of the Patriot Act. But
I mean, and again, that's the thing. That is the thing with rights and with depending on government to protect and respect your rights.
Okay, hold on. I was just want to throw these numbers out real quick because I was curious and I looked them up while you were talking. I live in Contra Costa County, California, right, which is one of the 9 Bay Area states. I have like 1.15 million people in my county, right? 1,150,000 people in my county. According to Google search, there were 317 concealed weapon permits issued last year.
Over 1 million people in 317.
Yes, I live in a May issue county. We have no open carry, and the government only allowed 317 concealed weapon permits.
You know what's ridiculous is even Wisconsin has constitutional open carry, but it has a lot of restrictions on it. And one of those is that you can't open carry to a place that sells alcohol. Chris, you also live in Wisconsin. How many places can we ever go that don't sell alcohol?
Just about nowhere.
I can buy right now. I can go buy a fifth of vodka at my local gas station, my local grocery store. Almost any restaurant will give me carryout of alcohol. So I can't carry to any of those places. I mean, we practically sell it at the library here.
Even if you're not drinking.
Yeah.
Yeah, even if you're not drinking, you cannot open carry.
Yep,
now you can if you go through the process and you decide you're going to get your permit and you get caught concealed carrying in a place that serves alcohol, as long as you blow 000, you're fine.
Yeah.
Technically speaking, as long as you're under the legal limit of 0.08, you're okay.
But even if you're on private property, holding a weapon, even if it's unloaded, fun fact, if you are holding a weapon on private property and you have been drinking, you are guilty of breaking the law in Wisconsin.
Hashtag train how you fight.
Well, yeah, I mean, that's
Wisconsin.
That's why I usually train naked and drunk.
I know. We've seen the pictures in the Telegram chat.
Sorry, Andrew. I didn't mean to post those.
Nothing but a vast bottle of fucking Jameson in one hand and an AK in the other.
No, your vertical grip is the Jameson. You just run a crazy straw out your mouth. Man.
That would be fucking. I wonder if I could do that. I bet you I can figure it out.
No. So yeah, I don't have anything else to add to this, you guys.
No, I mean, I just, again, that's. Well, my point was this is what happens. This is what happens the moment that you decide you are going to let government get to dictate your rights to you, instead of understanding that
apparently not just our government. It was the government in 1348 that is dictating your freedoms today in a different country on a different continent.
What happens when your judges decide that a pair of monarchies get to dictate your rights to you. I mean, it's, you know what I mean? But that's where we're at. We're at this point where I think you have to be a complete imbecile to not see the arbitrary nature of restrictions on rights as a direct result of government trying to regulate them, where they're not just this natural right that you get, that you have, whether government says so or not, which is the reality. The moment you try to go, well, just a little restriction, just a little poison in my water is okay. Well,
not just hold it. Not just that. Like even. Oh, God, I want to be a white pill here, and I want to say that when SCOTUS overturns this, it will have already shifted the Overton window on the argument, though.
Yep.
Because there will be people that will be exposed to this that would be like, hey, that's a good idea. Look what the Supreme Court, or look what the circuit court said, blah, 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 blah. And even though SCOTUS will overturn it, they'll still reference this.
Yep, the damage will already be done.
Yeah.
Well, yeah, I mean, all of those, there's so many. So in this book, there are so many court cases from state Supreme Courts and circuit Supreme Courts that, and appellate courts and everything that have been referenced so many times by so many other courts, because once it happens, once the ruling exists and the opinion is written, it becomes jurisprudence. One of the other things I want to mention too is there are a lot of organizations that fired amicus briefs in this case. And if you don't know what an amicus brief is, basically it's a friend of the court thing. It's a brief that you file to the judges as a, hey, FYI, here's information that you might need, right? There are tons of organizations that filed amicus briefs. There are, however, two conspicuously absent from that list.
The NRA.
And the ACLU.
Well, yeah.
What a shock.
The firearms case, the ACLU is not going to say anything.
Right, but the NRA also didn't bother to say a damn thing.
Mm-hmm.
about this case. The FPC filed 2 amicus briefs. The GOA filed at least 2 amicus briefs. The AR-15 GOA filed one. There's several other firearms rights organizations that filed them.
All right, so
NRA
I have a, oh god, this is a long piece. I was gonna say I should just read the FPC's piece on it, but
I was gonna say
we got very long.
We got
and
45 minutes, so we can at least do some of it.
Oh yeah, okay, I'll just read through it. So this is Firearms Policy Coalition. I will link this as we do with all articles.
Real quick though, I want to put something into perspective. So Jason, your county, you said you have 1.1 million people in your county.
Yes.
And there were how many permits issued last year?
317.
Okay, my county has 28,000 people in it.
Mm-hmm.
And according to estimates, as reported through a FOIA request that I've seen, almost half of my county has permits.
I wonder how many are in La Crosse County. I'm super curious now.
All right. So Firearms Policy Coalition, this is FPC condemns Ninth Circuit Court of Appeals opinion upholding carry ban. Today, the Ninth Circuit issued an in-bank opinion on Young versus Hawaii, a case which Firearms Policy Coalition filed a supporting brief, where the court upheld Hawaii's de facto ban on the public carrying of firearms. Hawaii's law, HRS 134-9A, requires that residents seeking a license to open carry a firearm demonstrate good moral character, that he or she will be, quote, engaged in the protection of life and property, and urgency or need to carry a firearm.
See, you see what I mean about the good moral character shit, and how subjective that is.
It's a political purity test.
Well, see, but again, this is again to go after the disenfranchised and the lower classes.
We would not apply if it was for the the good moral character.
Oh, that fucking no way.
Nope.
In practice, virtually nobody ever demonstrated a strong enough urgency or need to be issued a license, so the license requirement operated as a prohibition. In 2011, George Young submitted 2 applications for open carrying license. Both were denied because he failed to demonstrate a sufficient, quote, urgency or need. Young challenged the denials in court, arguing that the desire to carry a firearm for self-defense was all the Second Amendment required. After the district court ruled against him, a 3-judge panel of the Ninth ruled in his favor, upholding that the Second Amendment must protect some method of carry outside the home. And because the Ninth Circuit had previously held that the concealed carry is not protected, open carry must be. But then the Ninth Circuit decided to rehear the case in block, i.e. before the 11-judge panel. The en banc court held that Hawaii's open carrying law did not violate the Second Amendment, rather that the court determined that because history demonstrated, quote, a long withstanding tradition of English and American law of government prohibiting certain weapons from entering public places as a means of providing domestic tranquility and forestalling domestic violence, there is, quote, no right to carry arms openly in public.
Traditionally, I mean, if you look at the papers written by the people who actually ratified the Second Amendment, who debated it and things, the need to promote domestic tranquility was usually used as a justification for the Second Amendment.
Well, yeah, people are a lot more polite when everybody around you is carrying a weapon.
Yeah, you are much. I mean, and the funny thing is like criminals understand this. Criminals understand that if everybody has guns, if everybody is armed, then nobody's going to try to rip anybody off. Because you could die in the process. So everyone's much more polite. They're much more likely to just do business on the up and up. How is it that criminals understand basic human nature infinitely better than a bunch of fucking judges?
Because they're bureaucrats, essentially.
Well, I mean, that's the thing. I mean, like, I realize that I answered my own question. They're judges, but ostensibly, right? They're supposed to be better at judging human nature, better at understanding these things. And yet what they've done is they've demonstrated that they don't even have the same understanding of human nature as a bunch of crack dealers on a corner in Brooklyn.
Yeah.
You know,
Yeah, I'm not gonna read that whole thing. It's just
I want to point this out, as just an example of exactly what we're talking about with an armed society as a polite society. Before I'll admit it, I went ahead and got my concealed weapons permit just because, from a tactical perspective, having a concealed weapon makes more sense than carrying one openly. But before I got it, I did open carry my pistol that I had at the time for a little while, and people look at you really funny when you're open carrying a weapon. They're like, "What? What's going on?" But I can definitely tell you that while I was open carrying my pistol, nobody ever's had a bad word to say to my face.
You know what's funny is I applied for a concealed carry, I think like 2016, and it took like 6 months for me to get rejected. And then I found out that you can conceal carry in California and it's only a misdemeanor.
Well,
yep. I think it's only a misdemeanor.
But it's a felony if you have more than 10 rounds.
Ah, yeah. See, that's where they get you. Well, see, yeah. my G43
10 rounds is part of our assault weapons ban.
Yeah, but I mean, that's a whole nother topic. The weapon, the round restriction. Well, I mean, is it another topic though? I guess
really. No,
it's a topic.
I mean, yeah, it's related. I mean, it's the same thing. It's that arbitrary nature.
Is it? Would it be acceptable for a government to limit the size of the sword you could carry? I mean, if we're talking 1348, I mean, sorry, that's more than 2 of the king's feet long. You can't carry that openly.
Well, yeah, I mean, and the thing. Yeah, the thing is too is remember that traditionally, especially back then, and in cultures that have that time period of development, I need to specify because of where I'm about to go here. It's generally used, laws like that are generally used to intentionally disenfranchise, make harmless, and humiliate certain segments of society. Mm-hmm. And to that effect, just before the major samurai rebellion in Japan, right? And remember, in the 19th century, when Commodore Perry rolls into the harbor outside Tokyo, right? He shows up. Was that Edo at the time? It might have still been Edo at the time. But anyway, when he rolls in,
it's your story.
And shows up with an armed American fleet. I also just want to reiterate here that America sent a gunboat fleet to a sovereign nation to point their guns at the home of their ruler and demand they open trade with us.
That doesn't sound like the mob saying, "Hey, give us money or you might have a fire." At all. Totally doesn't sound like that.
Just to point out. But so when they, not long after that, right? They're just coming out of like a medieval period for them, because up until that point, remember, you had shogunates, you had these local rulers, you had like feudal lords and a feudal system, and like that is what Commodore Perry shows up with a steam-powered gunboat to in Japan, because they cut themselves off so completely. They, from the West, largely, they are like still medieval. But because they're still medieval, swords are still very common. And the samurai class were a specific class within Japanese society, carried swords and everything else. They actually had like 3 different swords on them at any given time. All these things. When the emperor declares that they can no longer carry swords in public, it isn't for public safety. It's because the samurai are starting to rebel because they see the westernization of Japan as a threat, and it's to humiliate and disenfranchise the samurai class. These people who previously were these elite warriors, right? They ruled society, and now they're just slapping them down, and they're doing it with one move by not allowing them to carry their swords.
Yeah, change the culture. Once you change the culture, you can control the people.
Yeah, I mean, it's look at imagine if you went to, I don't know, any number of Middle Eastern countries and said you can't carry an AK-47 anymore.
when the U.S. military's occupation of Iraq, the Iraqis were allowed to carry fully automatic AKs.
Oh yeah, most of the Middle East has almost no restrictions on firearms. You can go to like a store, like I've actually been to one in the UAE in Dubai, and there's a store that you can just walk into. It's just like it's like in a fucking strip mall, all right? And it's this little store, and you walk in, and it is full auto guns from front to back, left to right. They have a lineup of like not only gold plated AKs, but like full on like bejeweled, like bedazzled, but with actual diamonds AKs and all this ridiculousness. There are RPGs, actual RPG 7s. There's 14.5 Russian machine gun, all of this stuff. Do you know how much violent crime the UAE ever sees?
Very little.
Very, very, very little. Because any one of these rich motherfuckers that you might want to rob may in fact be hiding a CZ Scorpion underneath his fucking robes and just go brip and fucking annihilate you. I would do
dirty, dirty things to own a CZ Scorpion. A legit CZ Scorpion.
A legit CZ Scorpion, not this semi-auto horse
not that Evo crap.
Yeah, I was gonna say like an actual. Well, do you mean the PCC or do you mean the original Scorpion, the
original 32 ACP?
Those things, I fired them
stock. Oh
yeah. Oh, I fired them with the stock folded in full auto, and because they're 32 ACP, you would not believe how controllable those things are. It is amazing.
Oh, I'm sure.
It is amazing. It's truly. I mean, and when the stock, you can write your name.
So erect.
But I mean, that is the comparison right there, right? Like you have in one place, you have an enormous amount of weaponry all over the place, and not just small weaponry, like full on rocket propelled grenades and mortars. And
not only do they have it, but there's the culture of firearms, right? I mean, there are countries in the Middle East that have firearms on their flags.
Several.
Right? So I mean, there's a culture of firearm usage, not of firearms for hunting, for protection, for defense of life and property. Here in the United States, that's getting legislated out. That's what this
more
is
than
about.
Legislated out. Being more
Hawaii's
than
law.
legislated out, you're talking it's being phased out by the 13-year, $15,000 indoctrination camps.
Public schools,
it's being pushed out by just the overall stigma that the propaganda wing of the U.S. government is pushing.
Well, yeah, I mean, to go back to circle it back to this article, right? The Hawaii's law, right, in regards to open carry, is based on a 169-year-old law, right, going back to what was it, like the 1850s, right?
So it's a law of a sovereign nation, not of the United States.
No, what I'm getting at is the culture, like the Rainbow Warriors, the Polynesian warrior culture was very strong in Hawaii. I mean, look what they did to Captain Cook.
Well, yeah, I mean, you got to remember that the Hawaii of the time of this was a Hawaii that was just finally being united under. Was that Kamehameha? I think that was Kamehameha.
It was Kamehameha.
It's just finally being united under Kamehameha, and before that, it was like so many other Polynesian settled islands where it was war.
Tribal. It was tribal. Yeah.
It was very tribal and it was very village centered. And it was one of these things where what Kamehameha was trying to do was bring people together by saying, hey, you can't carry these weapons anymore. Like, I need everybody to be disarmed. I want everybody to talk about things. I want everybody to do these things. And it's a completely different environment than now. Number one, absolutely. It's a totally different culture. It's a totally different idea than what you have now. Because remember, right now, Hawaii is under an onslaught, an assault by methamphetamine in particular.
Mm-hmm.
A full-on fucking open assault.
Damn white people ruin everything.
Well, I'm sorry, we're good at chemistry. But, I mean, it's this. I'm not even completely white, so
that's why I know. That's why that kind of stuff. That's why nobody listens to us.
I know, right? It's. But I mean, this that culture was one thing, and it was a monarchy, FYI. But now you're talking about a bunch of people who are possibly dealing with drug addicts. They're dealing with large numbers of drug addicts. It's an epidemic, the same as it is across the American South.
Yeah.
I mean, if you've ever been to Georgia or Alabama or Arkansas,
we have a place. There's a place like, I don't know which direction, south. So it's like 12 miles east of me. It's affectionately called Methyl Island.
See,
yeah,
I mean,
it's not an insignificant problem in places like rural Wisconsin. Although in Wisconsin, I will say opiates are a much bigger problem than
opiates are a way bigger problem here.
But I mean, it's not an insignificant problem in all the way across the United States and in a lot of places across the world. And I don't know if you've ever dealt with somebody who is high on meth, but they're
once or 9 times.
I mean, they're just about as unreasonable to deal with as PCP users.
I made a post on Facebook yesterday about my neighbor must have gotten their Uncle Joe stimulus because they were cutting the grass at 9 p.m. on a Thursday night.
Oh, yep. They see, I mean, there's, I've always said there's a point where you've done enough coke where you're like cleaning a counter and you're like, am I wearing through the surface? I don't know anymore. It's starting to mock me, this spot right here. And
tweak or die.
But but that's the thing is, like, this is a completely different world now that they're dealing with, where personal defense is, again, a really, really big thing. You don't have a uniting force with meth addicts.
But this court order completely contradicted itself several times.
Own rulings.
Its own rulings.
Not only that, but it completely contradicted the various rulings when they made the statement of other courts. When they made the statement about, they were trying to reference something that completely contradicted Warren.
Yeah.
As a justification for why people don't need weapons. It's like, are you fucking kidding me?
Yeah, it's this again is why you do not try and leave your rights or trust your rights to government. Do not give control of your rights. Do not accept control of your rights by other people, because it will become this arbitrary back and forth random horse shit. Depending on who's in charge.
Such as the bump stocks.
Gosh, like bump stocks,
there
maybe?
Just a ruling on that?
Gosh, yeah, I feel like there might have been.
They just ruled and said that they weren't machine guns.
Yeah, because they're not.
They're not machine guns.
Well, they're not, but...
But I mean, see what I mean about how arbitrary, or the ATF's rulings with the, if you have a pistol brace, it's okay. Well, it's okay, but not if you put it on your shoulder. Well, I mean, it's still okay if you put it on your shoulder, but maybe not. But maybe it is. I don't know. It's
like the other big one now is with Boulder, Colorado, right? They ruled right they ruled that the the assault weapons ban was unconstitutional, right? Like 10 days ago or whatever it was. And then like 6 days later, they had the shooting. And then everybody's going, see, that's why we need gun control. See, the gun wasn't bought in the fucking city because there's only 2 gun shops in the city. And according to the mayor himself, the mayor says the gun shops in the city don't sell that type of firearm. So how would the assault weapons ban inside the city stop
nothing
from?
There's absolutely fucking nothing. There's no law on the books now, or any of them that are currently proposed, that would have prevented either that one or just about every preceding mass shooting that's ever happened.
No law ever has prevented somebody from doing something bad
that they want to do anyway.
It's reality.
It's reality. I mean, and you can draw it back. We were talking about drugs a little bit ago. You can draw it back to prohibitions on drugs. Look around. I mean, people are using drugs everywhere. And no law. I mean, the federal government still bans marijuana usage. I know marijuana is still illegal in the state of Wisconsin.
Cannabis.
Yeah.
Marijuana is its government's name.
Yeah. So cannabis is illegal in the state of Wisconsin. Okay. I can name for you 30 people off the top of my head that I am well aware that they regularly use it.
Yeah.
Actually,
and
so marijuana isn't actually illegal in Wisconsin. I mean, even cannabis isn't illegal in Wisconsin because Delta 8 THC is legal federally.
Yes.
So
right,
the wrong kind of cannabis isn't legal.
The proper kind of cannabis isn't legal in Wisconsin.
Oh, dude,
Delta 8.
Yeah, but no, Delta 8 is still present in plants. It's just usually associated with hemp. It's actually specifically listed in the federal law as a legal form of THC because it's so present in hemp, but they just assume no one would ever breed a strain that would amplify it enough that it would get you high. They were wrong.
Of course they were wrong.
As you said earlier, we're good with chemistry.
Yeah. Yeah.
And apparently genetics.
Yeah, but I mean, not only that, but I mean, that again shows how arbitrary this is. Even the prohibition of marijuana doesn't make sense because, well, if it's marijuana that has Delta 9 THC in it, or I think one other one, that's illegal. But if it has Delta 8 in it, well, now it's legal again. But the cops might still arrest you, even if it's just, if it doesn't have any THC and it's just CBD, you can still get arrested for it because there's that girl in Menards not that long ago who got arrested who had nothing but she had buds, but they're all CBD buds.
Yep.
In a container that was still sealed from the factory that is a legal CBD producer, and she had the paperwork to prove that it didn't have any THC. She was still arrested for drug possession anyway. So that's even more arbitrary.
Mm-hmm.
And makes even less sense. I mean, it makes as much sense.
It's no different than a guy that I can remember a kid in my high school got arrested because the school thought he had already, broken up buds on him. It turned out it was basil and oregano. And they still tried to charge him.
Yeah.
They tried to charge him with drug possession because it had the appearance of drugs.
Exactly. I mean, there's that person, I think it was actually in Italy, but there was that person who was arrested for it was like this massive $2 million like drug bust. And it turned out that it was like dried ground, like strawberry Haribo. Like it was fucking candy. Like this is how arbitrary and absurd this is. And the thing is when these are the same people, because remember, these are the same people who enforce these absurd laws in this arbitrary manner are the ones who are going to come for your fucking guns.
Mm-hmm.
When these are the people who you are trying to argue with about what does and doesn't make sense, what is and isn't your right, you can't win against these people because they'll just change. I mean, it's Kelvin Ball, right? Like I've brought up Kelvin Ball before, and I'm sure that like the Gen Zers are blinking right now at their screens going, what the hell is Kelvin Ball? So
There's
there
no
used
Gen
to,
Zer that listens to us. Are you fucking kidding me?
well, there might be. I mean, just say like, so if you're very young, you may not remember, but there used to be this comic strip called Kelvin and Hobbes. And in it, Kelvin came up with a game called Kelvin Ball, which was completely arbitrary rules. Every time he wasn't winning, he altered the rules so that he would still win.
That sounds exactly like government.
That's how this all works. As soon as they're not winning, they will change the rules so that they still get to win.
Or they'll completely try to stop playing in the case of where we've talked about this on the show, talking about gun control, where the ATF has dropped cases on people that they were trying to charge with manufacturing firearms, but what they were
manufacturing ARs,
ARs, and then selling them when in fact there's no portion of an AR that meets the definition of a firearm.
Mm-hmm.
And because that was going to be their defense, they're like, nope, we're just going to drop charges because they don't want that on the books.
Yeah, if I can't win, then I don't want to play. I mean,
right.
This is by trying to put your faith in government at all, on any level, this is the stuff you're acquiescing to. This is what you're subjecting yourself to. Immediately is this totally arbitrary stuff. And oh yeah, you have First Amendment rights. Oh, but you don't have a right to say that the government needs to go. You don't have a right to say that you don't like the wrong people. You don't have, I mean, it just starts getting manipulated, starts getting changed. You start getting federally investigated because you say that the government is tyrannical.
I have no idea what you're talking about, Andrew.
The government is tyrannical, so the government is going to investigate you for saying that the government is tyrannical.
The government is going to make sure that it shows you how tyrannical it is.
Yeah. Oh, you think I'm a tyrant? I will show you, tyrant.
Oh.
I mean, but that's
where we are.
Yeah. It's, I don't understand how people still, like, you still have people who will argue, oh, well, don't fight back. Just let it come out in court.
God damn it. I saw that on the fucking 3per on Twitter yesterday or Twitter today. I
saw a bunch of people saying shit like that to Omar, the guy that was with everything that was going on in Michigan.
Mm-hmm.
And they were like, oh, just it'll come out in court that you didn't do anything wrong. Just surrender. And it's like, they're already here. The army is I mean, granted, it was all local cops, but the army is here.
Well, how do you define an army? Because I would define an army as a large group of armed, angry men.
Right. And I agree with you. I agree with you.
So,
but,
let's not get into the Brandenburg stuff on this one.
Yeah. But I mean, what it amounts to, though, is people will say all day, oh, fight it out in court. But clearly you can't, because this guy just tried and the court disagreed with itself.
2012, or he applied in 2012. We're 9 years later.
Yep. And the ruling by the 3-judge panel was in 2018.
Yes.
Yeah. So even 3 years after that, yep. I mean,
5 years after this guy applied, the Ninth Circuit and the 3-judge panel said it was okay.
6 years.
6 years.
6 years after he applied, the Ninth said, yeah, hey, he's right. And then 3 years later, they're like, well, maybe not.
Right.
And we're going to use a law from 1348 to back up our claim that it's
1348, 1860s, back, and both laws are from monarchies.
Yeah, and
monarchies before the existence of the territory in question.
Well, and the thing that I think in one of many things that infuriates me, I think one of the most easily justifiably infuriating things is that the same people who will celebrate things like this and say, yeah, we don't need guns on our streets, blah, 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 will also say that they're so pro women's rights and they're so anti-domestic violence and they're so, oh, it's all about, you don't care about women and everything else.
They don't care about women because they don't care about women having the means to defend themselves.
The people saying you don't need guns, we don't need guns on our streets, weapons of war, blah 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 blah, just spent an entire year saying all cops are bastards, Black Lives Matter, and defund the police.
Which is,
and now they want the cops to be the only ones with the guns.
Right. Now, I will say I know quite a few people that were taking part in all of that all cops are bastards shit. And they're right. That was going on last spring with, granted, burning buildings of private businesses. Please don't do that. Just burn down the police station or something. Brandenburg-ville.
It was mostly peaceful.
Mostly peaceful.
Yeah, they were like 90% of them were peaceful.
But I know some people that were adamantly anti-gun, say 15 months ago, 12 months ago.
Yeah.
When everything started going to shit in the major cities and people started burning everything down, immediately like, dude, what do I need to buy?
What was it? FBI said like 23 million first-time gun purchasers in the United States last year.
And those are just the ones. And those are just the ones that went through a NICS background check.
Well, not even just legal. Just 4473s, because like in Wisconsin and a lot of other states, I know not California, but in Wisconsin, a lot of other states, private party sales are completely legal.
Yes.
So but I mean, like, keep in mind, like this, where our personal weapons purchases are higher than they have like ever been since we kept track of them.
And now they want to try to ban more of them.
Not only that, but like the 3D printed industry, the Ghost Gunner 80% industry, the Ghost Gunner itself, Defense Distributed, like those are they can't keep those in stock.
Well, and they want to ban this, right? They want to ban an 80% lower. Because they're like, well, that's
80% lower though. It's a block of aluminum.
Well, one, it's a block of aluminum, but they want to ban this. Do you know how easy it would be for somebody to go, okay, well, then you also have to mill out the magwell, and you also have to drill the magazine release.
Like, and we talked about before about how arbitrary it is. Like, they want to ban 80% lowers. Okay, well, then the market's going to make 75% lowers. And then then if they go to try to ban 70% lowers, 75% lowers, the market's going to respond with 70% lowers.
Yep.
That's just the way it is.
Until you get down to a single block of aluminum that gets sold and then a CNC machine that somebody develops for real cheap, and then somebody can just mill the entire thing themselves from a block.
Looking at what Andrew's got there, he's got an 80% AR. This is an 80% kit that I purchased. It's not the Lucky Gunner kit or whatever the hell it was that they went after everybody for. That's a firearm because you're selling everything that you need. No, this is a piece of plastic that I have to work.
It's a paperweight.
It's a paperweight. in a box.
Yeah. And and that's the thing is that, again, and I've mentioned them on the show before, like Ares Armory Research Services, they specialize in talking about improvised weapons and weapons in conflict zones and how those things develop. And they will all day talk about, in fact, there's even an episode that the guy from it does with, I think, Danny from the Cody Firearms Museum on History Unloaded, talking about improvised weaponry and talking about how it's basically impossible for you to ever stop people who want to get guns from making guns because they're simple machines. Mm-hmm. And there is no way to stop people from making simple machines. There is not that much special to a gun. It doesn't operate by magic. It's a few pieces of metal that resist pressure. And
I have personally fired on multiple occasions a slam fire 12, 20, and 410 shotgun.
Well, yeah, I mean, we not even that. Like, we can get into that. We can talk about, like, as I mentioned, the 80%, right? And if they're gonna ban 80, the market will respond with 75s, and then 70s, and 60s, and 50s,
and so weiter.
We also got the rise of the 3D printing, which if I don't know how many people follow it, but there are hundreds of thousands of 3D printed firearms out there. and they are getting better every single day to the point where they can now create their own electrolysis barrels, right? Where they can do the rifling for the barrels themselves.
Yep.
The Dagny dagger from Atlas Arms, right? That is a homemade manufactured ammunition. They're 3D printing the ammunition, the brass, right? They're 3D printing those and the shotgun shells, and it's completely unstoppable. It's completely unstoppable.
We've said many times, you can't stop the signal. Once it's out there, it's out there. You're not going to stop it.
Defense Distributed, I think it was like 2017, 2018 or something like that. They have a tombstone outside their office, and it says gun control.
Yep.
Mm-hmm. Well, I mean, and that's the thing. I mean, like, even going back to World War II, right? And the Philippines and the Philippine guerrillas fighting the Japanese. They had their own slam fire shotguns that they made. Actually, it got Richardson Industries made in the U.S. for. It's got to just be nostalgia is the only thing I can think of why you would make it, but it's like an exact replica of the shotguns that this guy developed. He was I want to say a colonel in the U.S. military who wound up getting captured by the Japanese and liberated by the. I don't remember. He might have been a pilot. I don't really remember, but he was a U.S. military member. He winds up fighting with the guerrillas. He helps them develop these shotguns. He comes home, founds Richardson Industries. His last name was Richardson, obviously, if you want to Google him. But he creates the Philippine guerrilla shotgun, and it's basically a barrel that you literally pull off of the front of the gun, and it's got a fixed firing pin.
Mm-hmm.
And you load a shotgun shell, and when you want to fire, you go thunk.
And it goes,
bang.
Slam fire.
Yeah.
And
it's a slam fire.
It's when you look at it, the fact that anyone would buy this from a manufacturer boggles my mind, because it's like literally like just this block of wood with some steel pipe on it, and that's all there is.
Yeah.
That's
all they are.
There was a couple of those turned in at a buyback in Florida.
I remember seeing that article. Yep.
And it was like
he made 3 of them.
He made three of them, and they were like $17 total or something like that. He said.
Yep. And when he turned them in, they made him shoot them. They made him shoot them to make sure that they worked.
Yeah, and then he got the $200 each for them.
Yep, that was great. It had like a block of 2x6 on the back for a stock, a piece of steel conduit for a grip,
steel pipe,
to hold the back, and then there was a steel grip on the front, and you just pulled it back, and it went bang.
Yeah, see, like this is the Richardson. It's disassembled. It's 2 pieces.
Even that's more fancy than what this guy did.
Oh yeah.
Well, yeah, but I mean,
that guy used like bar clamps and stuff like that, exhaust clamps to hold
exhaust clamps
work together. It was great.
Yeah,
but I mean, like the point though is that how simple like this is. Yeah, see, like there's another one. That is the original version. It's. How simple is
like
that?
Guns.
Yeah, it's a piece of wood, like literally like just a piece of like 6-inch thick, not even wood that's been not even really turned, kind of just sanded and cut into the rough shape of a stock, and a piece of metal has been, seated in it and like band clamped in there with some screws, and then you have this other pipe and a little handle. And and the original ones didn't even have a handle. It was literally just you grabbed the barrel and pulled it back, which is probably going to get a little warm, but but that's all. Yeah, but that's all it takes to create a firearm. And these people are under this impression that by passing all these laws, by doing all these things, that they can magically make that not happen.
Well, and you could, if you really want to get complicated, for about $80 to $100, you can get everything that you need to build a 9mm submachine gun.
Yeah.
Oh yeah, submachine guns are easier to build than semi-autos because submachine guns are just one sear and a fixed bolt, or an open bolt that just travels. That's all there is. It's just one little sear that gets pulled down and a spring and the bolt. And that's all you need. And submachine guns are the easiest weapons in the world outside of a slam fire shotgun to produce.
Yeah.
Yep.
But for some reason, the magical words on paper are going to stop everybody from acquiring what they want.
Yep. Can use the rock, so it doesn't matter what you try to ban.
Yeah, it's. I mean, and that's the thing is,
it's
not about
song,
weapons. It's not about weapons. It's about control. And at the end of the day, I mean, I hate to break it to you, but Second Amendment's about all I need.
Yep. All right, now that we just got kicked off of YouTube.
So. Well, we'll be on every other platform, so.
Yep. So, all right. Throw out your plugs. Let's get out of here.
Buy Dierka's book.
Yes, linked in the description.
Check out Poppin's patches. He's got some awesome patches. They're super great. I actually
top quality.
Absolutely.
Yes, I am sending out a bunch of them. I'm sending out the Thron's, the Election with Sus, which is a limited edition one, by the way, and I have the limited edition card. They'll go with it to the lucky receiver.
Oh, they have
a bunch of these.
They have the new Violet Community Standards Facebook one now too. That one just dropped.
Yes.
Yeah, Dave actually sent that to me. He said, I think this has your name written all over it. He sent to me. But check him out. They're really high quality patches. They're super awesome. Very topical. He's got like 80s, priceless. 90s. Yeah, they're good prices. He's got 2000s, 80s, 90s. He's got Marvel. He's got, themed. It's a bunch of crossover stuff. There's all sorts of neat, clever stuff. He's got a Why Not Zoidberg.
It's Zoidberg is Yondu. Jesus Christ, I just saw that.
I'm Yondu, y'all. He's got a bunch of cool ones and awesome. Definitely worth checking out. Also check out thebeardstruggle.com. Use code InkedAnarchist15. Get 15% off of your beard care products. Care for your beard like a fucking Viking already. It deserves it. Also, check out Valerio. It's shopvalerio.com. Use code InkedAnarchist25 and get a full 25% off of your order. They have awesome sunglasses. They have awesome watches. The sunglasses that I got from them are the replicas of the Django Unchained sunglasses, except in black, so they look a little less steampunky, but they look awesome and are totally worth it. And make sure that you check them out and get some cool stuff. Save yourself money. Use my codes. And also support me by using my codes, because that would be cool if you do that.
Yeah, ditto what that guy said. Linked in the description. So,
and I would also, going back to Poppin's patches, I just want to point out that if you go and shop his t-shirts, the very first option, you will see a Mandalorian helmet with a very unique print on it.
The Boogalorian.
The Boogalorian helmet. That is it was a collaboration between Andrew, myself, and Dave from Poppin's Patches. So
that's our design.
That's our design. Go buy it.
But it's not a fucking patch yet.
Well, you know what? We tried to get him to make a patch. I don't know why he hasn't yet, but
yeah, we tried to get him to make a patch, but the fact that he made it as a shirt, hey, it's a step in the right direction.
Yep. So,
I'll take it.
Right. I don't have anything.
Nope. That's about it.
I got nothing.
I'm uneventful.
Yeah. Refuse, resist.
Yep.
Refuse, resist, and live free.
Yep. Support resistance grade weaponry.
Exactly.
All right. We'll catch on the next time. Peace.
Peace.
Boop.